What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we're cruising officially, but I had to talk about this. Ted Daniels reached out to me, said they had some breaking news on Kelly Dever. You guys know she's been a big topic of conversation on this channel, and we have to talk about it. Will she be added to a Brady list? What does it mean? Why? What did Jackson say about it? And what did Commissioner Cox, who met with Kelly Dever about this case, or did he have to say in an interview? And at the end, I will tell you what I think about Hank Brennan and how much money he made working on this case. Did he really work those hours? Was he worth that $250 hourly rate? And who really has to answer for all of this at the end of the day? Stick around to hear all my thoughts on that. Make sure you guys hit the like button. Make sure you're subscribed. Throw your questions in the comments. I'm going to try to be in the live chat if I can, if the timing works out with the time difference here. But let's get into it, folks. I can't wait for the comments asking if I have lipstick on because I'm wearing chapstick. They're a little chapped, even though it's a million degrees here. But when I heard about this, I was like, why is this, that big of a deal? It's not that different. What's going on in this? And then I read the Brady letter that Jackson wrote. It's addressed to Commissioner Cox. Then I read Commissioner Cox's comments and I was like, oh, okay, now I see what's going on here. So why is this a big deal? What is the Brady Giglio list? Well, you know that Brady material is exculpatory material, which proves the defendant's innocence, but that's not all. It's basically anything that's good for the defendant, including impeachment evidence. If you can use this to impeach a state or Commonwealth witness, then this is something you have to turn over if you're a prosecutor. So what Jackson wants is to put her name on a list so every criminal defense lawyer will know that impeachment material or Brady material of some sort exists on Ms. Dever. This is something that will follow her forever. And what it means is they know to ask for that information. And this can be on any case that she's touched in the past or that she is going to touch if she ever touches another case in the future. And what it also means is if the prosecutor doesn't turn it over and the defense later finds out she's on a Brady list, we could get a new trial. We could get a case thrown out potentially. There could be a mistrial. That is a major violation of a criminal defendant's right to a fair trial and the disclosures and discovery that they are absolutely entitled to. So it creates a big issue and a big problem. And you may ask the question, well, what if the commissioner disagrees? And he's like, nope, she doesn't need to be put on any Brady list. She didn't do anything wrong. She's perfectly fine. Her job is protected. We're not going to do any of that for Miss Dever. Well, if I was a prosecutor and I had Miss Dever on one of my cases, I would turn it over. I don't care if she's on a Brady list. It's absolutely Brady material. The defense is absolutely entitled to this information. And because they're entitled to this information, you must turn it over as a prosecutor. It's your ethical duty. You have to turn it over. You have to create a scenario where it is a fair trial for a criminal defense attorney and a criminal defendant. So that then begs to question the next set of circumstances. What happens to Ms. Dever's career? Will the commissioner look out for her? Do they protect their own? Did she fall on the sword and create a false memory and embarrass herself on the stand and really come off as a not credible witness? The jurors all said that. I thought she was horrible for the defense too because she was so combative and just such a bad witness overall, and they called her I was wrong. Overwhelmingly, the jurors that spoke about Ms. Dever seemed to think she made the defense's point. That's what it looks like. Why are you so combative? What do you have to hide? Why don't you just come and say what you need to say? So now, if you know, as a police department or as a prosecutor's office, every case she is ever on, you're going to have to deal with what Jackson put in this letter. Do you ever want to call her as a witness? And if you can't call her as a witness, can she do her job? Should she be allowed to do her job? Should the lives and investigations of people be put in her hands? And if prosecutors don't want to call her, how can you let her have that job if you're the police commissioner? How can you have her investigating cases? How can you have her in a position where she would ever need to testify about anything? And as you saw from Karen Reed's case, you don't have to be a detective to get on the stand and have to testify to something. It can be as simple as, I was looking at the video and this is what I saw. Would you want to call her if you're the prosecutor? Knowing this information that Jackson put in this letter that we're going to read together could come out. Will that affect her career forever? Will that make her lose her career? Or will they find some job for Miss Dever that she can do? It's administrative, maybe, that she doesn't have to testify. She doesn't put her hands or be in a position that she would ever have to be called to court, or they would ever have to turn over this information where she would ever be on any file, on any defense witness list at all, or relevant to any criminal prosecution. Seems near impossible, but if you're really going to look out for your own, and if you don't do that, what's Ms. Dever going to have to say about it? Has she painted herself into a corner at this point saying, I said I saw this, I created a false memory, this is actually the truth, that was a lie? Can she flip-flop again on it? And if she does, what does that mean for Commissioner Cox? We are also going to read some comments he made in an interview, which basically are happening at the same time as this letter that Alan Jackson sent. If you can't see it on the screen, don't worry, I'm going to read it. If there's some freezing here and the Wi-Fi is not perfect, I apologize. I'm literally cruising the Mediterranean Sea here, so we're doing the best. We bought the high-speed internet just in case something like this came up and we needed to talk about it, and it did. So let's talk about it. I'm going to make this a little bigger. All right. Dear Commissioner Cox, that's who Alan Jackson wrote this to, which is important. Pursuant to the obligations established under Brady, this letter serves as formal notice that a member of your department, Officer Kelly Dever, must be included in the Brady database. The grounds for her mandatory inclusion in the database are outlined below. As you are no doubt aware, as he's no doubt aware, just wait. He calls her this person in his interview, Commissioner Cox. Officer Dever was a witness called by the defense in the matter of Commonwealth v. Karen Reed, a high-profile M case that was tried for the second time in Norfolk Superior Court in April of 25. The case received extensive national and international media coverage. Officer Dever's involvement in the case stemmed from her interview with agents from the United States Federal Bureau of Investigations, during which interview Officer Dever explained to the agents in detail her observations of former Canton PD Police Chief Kenneth Berkowitz and Special Agent Brian Higgins of the Bureau of Alcohol, Tobacco, and Firearms and Explosives in the Sallyport garage of the Canton Police Department. She described seeing both individuals enter the Sallyport garage of the Canton Police Department, where the SUV in question was located on January 29, 2022. Officer Dever described in indelible detail, which again, Jackson's going to put his own language on this and, beef it up, but he's not wrong. And for people that are going to hate on Alan Jackson, he's trying to stay in the limelight, he's trying to do this, you know what I say? Fine. You can think that if you want to. Here's how I look at it as a lawyer. And I don't care if it's Alan Jackson or anybody else. We all need to stick together and make sure justice prevails. And when you find out something like this about an officer that may be on other people's cases, you're not just fighting for your own client. You're fighting for criminal defendants across the country. You're fighting for the Constitution. You're fighting for justice. This must be known. You must shine a light in darkness, or it will stay dark forever. If lawyers didn't do things like this, it would be so much easier for the government, for law enforcement to continue to railroad people when you have bad cops involved. There's a lot of great cops, a lot of great, amazing prosecutors. But the way you keep the bad ones out is shining the light. Officer Dever described in indelible detail that she witnessed Chief Berkowitz and Mr. Higgins go into the Sallyport and stay there for a wildly long time, and that she thought it weird that a witness on the case, Higgins, would have access to a seminal piece of evidence, the SUV, in the investigation. During her lengthy interview with the federal agents, she articulated her observations in considerable detail, including specifics about the monitors she was viewing at the dispatch desk. She described at length her observations of the two men entering the Sallyport with the SUV. Officer Dever claimed no issues with her memory, and she was clear with the agents that she made her observations in the afternoon or early evening of January 29, 2022, at the end of her shift after the SUV had been secured in the Sallyport. There too, the federal authorities provided a report of their interview with Officer Dever, both to the prosecution and to the defense in the Reed matter. In or about April 25, the defense issued a subpoena for Officer Dever to testify in the trial, and on June 2nd, 25, she was subsequently called and sworn to testify before the jury. During the testimony, under oath, Officer Dever changed her statement, claiming not that she did not make the statements to the federal agents, but that her observations of Chief Berkowitz and Mr. Higgins were a false memory. That's her own words. That's going to be important in a second. She maintained under oath and throughout her testimony that the events she described to the federal agents never happened. that memory she was recounting was false, and that the events she described did not actually occur. It is clear, therefore, that one of two things is true. Either Officer Dever lied about having a false memory, or she actually suffers from a condition that subjects her to false memories. In either case, her credibility and reliability as a law enforcement officer are irreparably compromised. If she lied under oath, Officer Dever is guilty of perjury. If she truly suffers from false memories, she is unfit to serve as a police officer. Her reports, statements, and testimony can no longer be presumed accurate, and any case, current or prior, involving Officer Dever must be reviewed accordingly. These circumstances bear directly on Officer Dever's credibility and represent impeachment evidence pursuant to Brady and Giglio. Absolutely. This is prototypical Brady and Giglio material. That's number one. Number two, I like to give people grace, give people the benefit of the doubt. But I also believe people when they tell me who they are. Officer Dever's own words said she created a false memory. So Jackson said either she lied or she created a false memory. Let's just go with what she said. Let's not call her a liar, okay? Let's say she created a false memory. If that is true, every juror, every criminal defense attorney, every criminal defendant needs to know that and hear that on any case she has worked or will work or is currently working on. He articulated it exactly how it needs to work, legally speaking, now that she has said under oath and told the world she creates or has created in the past false memories. And it is a fair question. Is that possible that you did that in this case, Ms. Dever? Created a false memory with a lot of detail. Any he said, she said situation, which guess what? We're going to have that coming when we hear Cox's interview. Given these facts, it is clear that it is incumbent upon your department to immediately include Officer Kelly Dever in the Brady database, and all information surrounding her claimed false memories must be disclosed to the defense in every case in which she is a witness or a potential witness. As you are aware, both the prosecution and law enforcement share a constitutional obligation pursuant to the Due Process Clause of the 14th Amendment to affirmatively disclose exculpatory and impeachment information to the defense in every case. The Supreme Court has mandated that when the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the Brady rule. And you can bet every criminal defense attorney is going to argue Kelly Dever's testimony absolutely is determinative of guilt or innocence. It would literally have to be, all I did was read the report, checked it for spelling errors, signed the bottom. I didn't have anything to do with this. That is not determinative of guilt or innocence. Actually, you could probably make the argument that if there's an issue in the report, the fact that she's the one that said it was fine, did she create a false memory and read, you see how it goes, but she would have to do something so insignificant for a criminal defense attorney to not be able to argue that her testimony would be determinative of guilt or innocence. Think about what happened in this case. Failure to disclose Officer Dever's intentionally false testimony and or her false memory condition would be a constitutional violation. I agree with it. Subjecting both the prosecution and the Boston Police Department to severe sanctions, the least of which is the dismissal of every case she touches. If it is determined that your department was on notice, which this letter formally provides, and the department does nothing to include Officer Dever in the Brady list and thereafter provide to the defense the exculpatory and impeachment materials in its possession, the sanctions can and will be far more extreme. So what's he saying there? Guess what? You can't claim ignorance or feign ignorance, as he likes to say. You can't pretend you didn't know. You can't bury your head in the sand here. I'm telling you, I'm putting you on notice. You know about this issue with Dever. You better let everybody else know about it that it could affect. If not, there will be problems. Please confirm your receipt and understanding of this correspondence along with confirmation that Officer Dever has been included in the Brady database. So who did he write that letter to? Commissioner Cox. Commissioner Cox was interviewed. I believe either the day of this letter, maybe the day before this letter, I think Ted Daniel said. And I'm going to read you that interview. I can't pull it up because I'm in Greece and there's something with, the international stuff. And so I'm just going to read it to you. He was questioned about the Karen Reed case on Thursday, specifically about one of his officers who testified in the Mansfield's woman's high-profile retrial. Kelly Dever, a current Boston police officer, was called to the stand by Reed's defense team on June 2nd. She was working dispatch for the PD when John O'Keefe was found dead. Let me skip ahead. Dever confirmed she had a conversation with Cox about the case at some point before taking the stand in the retrial, but she denied getting any guidance. That's going to be important. He just wanted me to tell the truth, Dever said of Cox. After speaking alongside Boston Mayor Michelle Wu and Suffolk District Attorney Kevin Hayden at a Safe Shopping Initiative event, reporters caught up with Cox and questioned him about Dever's testimony. I bet he hated that. Your name came up during the recent retrial of Karen Reed. You got a visit from Officer Kelly Dever. The defense implied you influenced her testimony. Do you want to respond to that? Cox was asked. Cox quickly answered, I have nothing to do with Karen Reed. Nobody wants to touch that. They want to get away from that, distance themselves from that. How is he going to deal with the potential promises made to Kelly Dever? What did he tell her? What is she going to expect? As a matter of fact, I didn't even know this person was associated with the Karen Reed case. I assume this person means Kelly Dever, rookie cop who the commissioner decided to have a conversation with. Very unusual. I have an organization full of over 3,000 people, and we support all our folks. The reality is that I get information passed on, whether those people are high or low, and I encourage everyone, Cox continued, if you want to work here and you belong here, then we're going to encourage you. I have no idea what they're talking about with Karen Reed. I had nothing to do with Karen Reed. No discussion about Karen Reed. There's only a couple of explanations here, and there's still more from that. Number one, either Cox is lying, wants to distance himself, has nothing to do with it, doesn't want to make like he told her to lie or change her testimony or anything like that. Or Kelly Dever's lying. She never had a conversation with Cox. She was just trying to fix things. Or Kelly Dever created another false memory, and I'm not making a joke there. It's possible because we know she said it's happened in the past. Or number four, and this would be giving everybody a major benefit of the doubt, maybe there was a miscommunication. Cox called Dever in. She's a rookie young cop. Says, hey, I just want to encourage you. Always tell the truth on the stand. You can make or break your career with how you testify on the stand, so always tell the truth. And Kelly Dever was stressed about being subpoenaed by Karen Reed's defense team, a high-profile case. All she's thinking about is Karen Reed. She took it to be, I thought he was talking about Karen Reed. Maybe he wasn't. Maybe there was a misunderstanding. He was just encouraging me generally because he didn't give me any guidance specifically about Karen Reed's case. I'd have to go back and listen to her testimony and see if that would even jive with all the specific details she gave, but that hasn't stopped her in the past from claiming false testimony or false memories. But that's not good. We have a he said, she said situation. And if I was going to argue for Michael Cox, you better believe an argument I would use is we're talking about a person he's disagreeing with that has admitted to creating false memories. Cox was then asked, did you tell Officer Dever to do the right thing? I didn't know she was even associated with that case. I was struck like, what do I have to do with the Karen Reed case? I've never said those words together. I assume he means the Karen Reed case or Karen and Reed together. So the fact is, it's much to do about nothing. Doubling and tripling down. I did not have a conversation with her about this. I did not tell her to do anything with regards to testifying about Karen Reed. That's not true. Cox was last asked, do you feel that you were inappropriately brought into this? He responded, that case is over. We've got a lot of other stuff to talk about. I had nothing to do with Karen Reed.
Your name came up during the recent Karen Reed trial. You got a visit from Officer Kelly Dever. The defense implied that you influenced her testimony. Do you want to respond to that?
I have nothing to do with Karen Reed. Matter of fact, I didn't even know this person was associated with the Karen Reed case. You know, I have an organization full of over 3,000 people, and we support all our folks. And the reality is that, I get information passed on, whether people are high or low, and I encourage everyone, right? And if you're going to work here and you belong here, then we're going to encourage you. I have no idea what they're talking about with Karen Reed. It had nothing to do with Karen Reed. No discussion about
Did you
Karen
tell Officer Dever to do the right thing?
I didn't know she was even associated with that case. So, I don't know. I was struck, like, what do I have to do with the Karen Reed case? I never have said those words together. And so the fact is, it's much to do about nothing. We have employees here that we have to develop and encourage and do things, and I do that for tons of our employees.
Do you feel that you were inappropriately drawn into this as some sort of boogeyman?
That case is over, and we've got a lot of other stuff to talk about. I have nothing to do with I was in the state of Michigan. So,
Thank you.
And we know the defense claimed the story completely changed after she went to Commissioner Cox's office. So they fully believe something happened there. He doubled and tripled down. That case is over. It's in the past. I want nothing to do with it. And maybe he's thinking there's no trial. Maybe these lawyers will go away and Karen Reed will go away and we can just be done with this, because if I just ignore it, maybe less publicity and public comments will come out. What do you think? What do you think about this back and forth? Who do you think is telling the truth? What do you think actually happened? I know it's bad no matter where we go from here when it comes to Cox and Dever. And I know if I'm a prosecutor, I'm turning it over. I'm letting every defense attorney know. I'm washing my hands of this. I'm not getting in the mud with these people. That's number one. Number two, if I'm a defense lawyer, I'm using it. I'm using it in every case because I'm going to say she can't be trusted. And I truly believe that. As a criminal defense lawyer, if she was working on any of my cases that I had, this would be question number one to her. You create false memories, right? How does she say no to that? How does she combat that? Lastly, I want to talk about Hank Brennan, because reports are coming out that the details show that he made over like $550,000 on this case, $250 an hour, over 2,200 hours. I've seen comments like $250 an hour is way more than he's worth, $550,000 just to lose. Listen, Brennan, no doubt in my mind, can charge way more than $250 an hour. And attorney's fees, it doesn't really matter in a private case what you think an attorney's worth. If the client believes that's fair and they're not taking advantage of somebody who's, under the influence, or they're not forcing them to, or holding something over their head, or blackmailing them to pay them high attorney's fees, reasonable attorney's fees are usually between the client and the lawyer. And if they think the lawyer is worth it, especially in criminal cases, you can't say I'll only pay you if you win. You cannot make cases contingent like that. On most of the cases I handle, wrongful death, personal injury cases, it is contingent. So how can you argue with a percentage that's a pretty standard percentage across the country, or at least state to state? Most of the state bars have suggested percentages that are fair and reasonable for contingency cases. You may think it's too much. A lawyer may think it's too little, but it's usually just between the lawyer and the client. Not here. So while I don't have a problem with that hourly rate, I don't even have a problem with that number to try a case like this. I would say it's low, frankly, for the amount of work that's happened in this case. Not everybody can afford that. I'm not trying to be insensitive. I understand that it's a lot of money. It's extremely expensive. I understand all of that, and I don't want to belittle that. But that's not the real major question here. Before I get to the major question here, one last thing, 2,200 hours. That is a pretty common goal for big law associates to have to bill on these, mergers and acquisitions. You bill all these hours and you're grinding away, document review in a dark room with no window. Yes, that is true. But I will say, nobody puts more hours in than a trial lawyer when they're trying cases. And when you're getting up to the last few months prepping for this case, and this case was one of one. I bet you Karen Reed's lawyers would all vouch for how many hours Hank Brennan probably worked, because they know it, because they worked it too. So the amount of hours that I saw reported doesn't offend me. I would absolutely believe Hank Brennan worked that many hours. People can call it into question if they want to, but I am not lying to you when I say when I try a case, if I'm not sleeping, I'm working on it. I go to hotels, usually stay away from my family. So it's literally, if you're sleeping 6-7 hours a night, you're literally working 21-hour days. And this is not somebody that's blowing smoke saying, oh, I work 20 hours a day, when it's actually not true, because it's like, well, when did you do this? When did you mow the lawn? When did you, whatever. It's like literally all I'm doing while I'm eating, I'm working. Especially if you have a team of people and you're ordering out or going to restaurants, you're talking about the witnesses coming next day. You're getting emails, you're working on jury instructions, whatever it may be, working on your PowerPoint for your closing. So I believe that these hours and the hourly rate don't offend me. The total amount, you can laugh at it if you want for what they got and what the result was, and I understand that. The real problem is it's not just between a private client and a lawyer. This is the people's money. This is taxpayer dollars that the elected officials, including Michael Morrissey, need to answer for. Why did you need to pay somebody this amount of money to try this case when you've got a full office of attorneys? Was this case not important enough to put somebody on it? Did no lawyer want it? Why did they not want it? Were they scared of the spotlight? Talk about it. That's an issue for me. You don't have a prosecutor that wants a big case like this? Or did they think it was unethical or inappropriate to try because they thought there wasn't enough evidence there? And if that's the case, the taxpayers need to know that. And the elected officials need to answer for that. It is an absolutely fair question that the people deserve an answer to. And that is the shocking part to me about this. That is the offensive part, the horrible part, the difficult part. You don't have a lawyer good enough to try this case? Prosecutors, they don't make as much money as most, really depends, right? The best of the best criminal defense attorneys obviously make more than prosecutors. Horrible criminal defense attorneys maybe make less than prosecutors. So I don't like to say all or never, but I'll just say generally, if you're a super successful criminal defense attorney, you make a lot more money than a prosecutor. But prosecutors have a calling a lot of times. They love it. They want to fight for this justice and what they believe to be the right side, the white knight. They would love a case to put away somebody that killed a cop. That opportunity to do that on the highest stage with all eyes on you. Prosecutors would love that. And there are very good prosecutors that are absolutely capable of handling these cases. We've seen them win these cases across the country. They all make the same amount of money, pro rata for where they're at, different jurisdictions. Of course, New York City, you make more than Tampa, Florida. But generally speaking, they're in the same brackets and they're able to do this and do this very successfully. So why not here? Why did we need Hank Brennan if I'm a taxpayer? Somebody should answer that question. And the people have absolutely a right to know. Why did we do this? And if I'm a victim in a case or my husband or father dies, why don't I get that? Why do I get the schleps that you didn't trust to try the Karen Reed case? And I'm not calling them schleps. I feel like Michael Morrissey did. Either they think you're unethical for trying this case or you don't think they're good enough. What is the other answer? I don't understand what the other answer could be. Can't be resources. That's not a problem, right? Maybe I'm missing something. Let me know if I am. But that's the big issue with the amount of money at stake here. I can't wait to see what you guys say in the live chat and in the comments here. Make sure you hit that like button. Make sure you subscribe. I'm out of here. Gonna go down, see what's going on with karaoke night with my family, which can get pretty wild. We'll see how that goes. Love you guys. Miss you guys. I'll see you soon. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.